Good afternoon. Calling our first case of this afternoon's call, Ravenell versus Auto Club Insurance Association. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, which you may waive. And if you choose to save time for rebuttal, we just ask that you keep track of that yourself. And you can begin when you're ready.
Thank you, Your Honor. Daniel Saylor appearing on behalf of the defendant appellant Auto Club. I'll just use AAA to describe them. And I will try and save myself 5 minutes, maybe a little less, depending on how we go. And I will waive the 2-minute free fire if you have questions, and I won't go into the facts. I'm going to assume that the facts are known, but I think they're important, so if you do have any questions, do ask about the facts. So simply put, this is the second case in a few years that the court has taken on equitable subrogation with the particular focus on the mere volunteer rule. And the timing was just slightly off. It would have been nice, I think, if, excuse me, if this case could have been taken at the same time with the Esurance case, because then we've got two cases with the mere volunteer principle at issue, and I think they make wonderful bookends to show where circumstances support the finding that the insurer is entitled to subrogation. They're not a mere volunteer. That's the Esurance case, and this one where the facts are quite different and the insurer who paid should be deemed a mere volunteer. Our Court of Appeals did not delve into the vast distinctions between the two situations and simply said, oh, if it's paid by mistake, they're not a volunteer. It's not that simple.
You spent a lot of time in your briefing focused on the volunteer question, but what we asked is really more about whether a mistaken belief that it was required to pay a claim is a factor in determining whether the insurer is entitled to equitable subrogation.
Right.
So I understand, I understand the argument that you're making, and it kind of melds into one another. But we're not really not focused on the volunteer status here.
That's just, I think, the title of the concept that the question you pose in your order, and as you saw, we paid some attention to the restatement of restitution, I think is what the restatement is titled. And they don't use the term volunteer either, but the concept remains. The basic, let me just briefly, the whole concept of equitable subrogation involves three entities. You got, let's say, an injured claimant, and then you've got an insurer. We'll speak in terms of insurance, it doesn't necessarily have to be, an insurer who pays that claimant for the loss, and there's another, a third party, could be another insurer, maybe it's a tortfeasor, who also has an obligation to pay that money to the injured claimant. So the insurer pays the claimant, and if it did so with an obligation to pay, whether it's a contractual obligation, a legal obligation, they pay the benefits or the loss, whatever it may be. They acquire rights by way of subrogation. They become subrogee. The claimant is the injured person is the subrogor. And then with those subrogation rights, they step into the shoes and can go after the other payer, obligor, I should say, whether it's a tortfeasor, such as if the insurer who paid is an uninsured motorist insurer. They pay benefits, but they become subrogated, and they can get money from the obligor, or another insurer who is deemed to be prior or has priority in payment. They both had an obligation, but the subrogee had a lesser obligation and therefore can recover from the primarily responsible insurer. But you have to pay with some obligation, some duty, you can't do it mistakenly or without any sort of obligation. The Esurance case shows that there is a little wiggle room on that. If there's not technically a legal obligation to pay, and yet they pay, they still may acquire subrogation rights if, in a sense, it's justifiable under the circumstances. It's non-negligent. They were protecting their own interest or protecting their insured. What the court said, if there's an arguable duty to pay, we went through a lot of examples in our briefs, but I think the court said it very succinctly in Assurance to boil it down to when there's an arguable duty to pay. Because otherwise, the relationship in this case, let's speak in terms of the parties, NGM sued AAA to recover money when they have no relationship whatsoever. There's not a contract between them. No tort was committed. They have no relationship at all. Only if they acquire rights by subrogation and therefore step into the shoes and acquire the claimant's rights against AAA, do they have any business trying to get money from AAA. And so we have the two tenets.
What steps should NGM have taken to prevent payments in this case on their part?
I'm sorry, Justice.
Well, what steps should they have done? What should they have done differently to avoid their
Simply examine their policy or the statute. They're consistent. Should we be paying this loss? And decide whether it's covered or not.
So what if they had gone through, let's say they had a book of process to do that, and they arrive at a result, yep, we need to pay this, and they were wrong. Someone made a mistake. And they paid for 6 months. They're just out?
If they, I'm sorry, I didn't follow the question. I couldn't hear all of it. I'm sorry.
So NGM says, they go through an entire process. They've got a book of like, this is what we need to check to see if we're on the hook for this claim. And a mistake is made by, a staff person, or there's a mistake in the manual. And so they end up paying for 6 months, but they went, they were diligent going through everything, and it was just a mistake.
Well, I think the devil would be in the details there, Your Honor. What nature of mistake was made? Because in this record, there is no record of how a mistake was made. There's no attempt to justify or rationalize the mistake. None. It was acknowledged throughout that they didn't owe it. They didn't realize it until a year and a half later, but one scratches their head to wonder why they didn't recognize it.
So on the flip side of that, you were always statutorily obligated to pay.
Correct.
And so NGM, their alleged negligence here, how has that prejudiced you? You were always on the hook to pay from the beginning. Someone else steps in, mistakenly pays. How have you been prejudiced?
Well, as I say, AAA was sued by somebody who has no relationship with us. And in order for them to establish any kind of a right, they have to meet the tenets of subrogation. And I understand it's not purely a matter of prejudice. I mean, we've argued in prejudice that the prejudice could be that had we known from day one that we were the insurer responsible, AAA knows how to manage a claim. It is, one of the biggest insurers in the state. They know how to handle a Michigan PIP claim. And
is there any obligation on AAA to have identified that you were responsible from the get-go?
no, in fact, on the contrary, that's another thing. That's why I say the facts are important here. AAA, within 3 weeks or 4 weeks of the accident, affirmatively reached out to NGM, who they might not have even known this, but they did a search because they were defending or preparing to defend on behalf of their insured the tort claim. It was a passenger accident. It was a pedestrian accident. And so they were looking into their tort defense and their tort claim, and they went on the ISO database and saw, oh, wait, this individual has just pursued a claim against NGM. And so our tort claims adjuster reached out to NGM to talk about a possible no-fault claim, because while not first in priority, our position would be lower in priority, but we would, as you say, potentially owe PIP benefits. We affirmatively asked, is this individual's PIP benefits being taken care of? And NGM assured, yes, they're being taken care of. We've done a coverage check and we're paying the benefits, so we're good to go. And if you look in their claims, their claim log, it shows that they checked and then reconfirmed coverage later. And that's why it went a year and a half without any, AAA didn't know they would have any connection to this PIP claim for a year and a half.
But you've used the term arguable legal duty, and now I'm understanding you to be arguing negligence on their part. Are these inconsistent? Is simple negligence enough if the party who took it on was just negligent, and if they'd have paid better attention, they would have discovered it? Is that enough to say no subrogation?
Well, now we're exactly where is the court going to draw the line?
Right, if we don't draw lines, you know what's going to happen. It's going to be in the trial courts, and everybody's going to argue question of fact, and you'll be dividing it up somehow in a settlement because they'll never go to trial.
Yeah, well, I think it's more than negligence. It has to be bare, simple negligence. Again, the devil's in the details. This record doesn't show where was the negligence, but I would say here you've got glaring gross negligence. I don't know how to describe it. The policy
How
itself.
would you define
What
gross
do we,
negligence?
yeah, on what record do we have that gross negligence? I mean, I guess, I understand your position is that we should decide as a matter of law, but if the degree of negligence, or whether it's actually gross negligence, or whatever that may be, is relevant to this, why is this a matter of law, and why is it at a minimum not a remand for the court to assess the reasonableness or the degree of negligence?
Well, if there was any attempt to justify the error, then I suppose you'd have a question of fact. It's a good question. But here, the policy, all they have to do is look at the deck page of their policy.
Okay, but I think what we're all trying to get at is, yes, this is the case before us, but if we're going to adopt a rule, what is that rule that you're asking us to look at? And put the facts of this case aside. It needs to be something that makes sense to all the trial courts. Is it just ordinary negligence? Is it something more than that? Is this is there something that should be a complete bar to equitable subrogation?
Well, I would urge the court to look closely at the restatement description of when the rights are recovered via equitable subrogation. And it talks about, has the two prongs, one where payment is made under a legal or contractual obligation, and then, or second, when, I wish I had the exact language in front of me, but it's certainly in the brief, but where there is a payment made to protect their own interest, to, where even though it's ultimately shown to be an error, there was a justification at the time. And again, Esurance is a perfect example where, at the time, they've got an insurance policy that, for all they know, is entirely valid and enforced and requires them to pay, only to find out later down the road, unknown facts emerge to allow a rescission. So there technically was no obligation to pay. The same thing in some of the examples we've shown where underlying facts were not discovered until later, which would trigger an exclusion, but they didn't know at the time of those facts. So there's some justification that makes the payment excusable, justifiable. But if there is no justification proffered, other than, well, it was complicated.
Let me try to see if I understand what you're saying. Arguable duty to pay, that related to Esurance, and Esurance really was a no-fault order of priority dispute, right?
There was really no question about priority because it was either assigned claims, which only pays when there's no other insurance, or Esurance pays because they are the insurance. What happened, so it was not priority, it was they thought their policy was enforced, it was valid, they had the obligation to pay. So they paid. Then subsequently, they learn of fraud in the application of insurance, and they did, so they rescinded, void ab initio. Only by operation of law is it retroactive and whoosh, there was no policy after all. And so technically, they had no obligation to pay, but it was justifiable at the time because they were being responsible, in light of what appeared to be a valid policy, they paid. So that was justifiable, excusable, understandable. But we have none of those justifications in this case. I've got 10 seconds to save for rebuttal unless there's any other questions. All right, thank you.
Yes. We're so ready for you.
Good afternoon. Mark Wright, Sr., appearing on behalf of Plaintiff Appellee and GM Insurance Company. The court did ask, whether or not it should be decided by ordinary negligence or reasonableness. And reasonableness is a question of law, but what the payment of benefit was, whether the payment of benefits was reasonable would be a question of fact. And negligence is the failure to take reasonable care under the circumstances. And Judge Zara, you Justice Shara, you kind of hit on it. If we're going to use either one of those standards, we're probably going to need a jury. And so then where does that all go? It ends up, and then, especially as it pertains to the Michigan No-Fault Act, you're going to have expert witnesses, i.e. lawyers or somebody using claims forever to testify. This is all going to be wasting time, litigation expense, and increased insurance premiums, which is what the No-Fault Act was not designed to do. My approach with respect to this is actually much simpler than that. And the focus should not be on the subrogee, but the focus should be on the entity the subrogee is seeking payment from. And more specifically, whether the entity was prejudiced by the mistake of the subrogee. If there is no prejudice, then the claim should be paid. Now, that would essentially do away with the, in quotes, mirrored volunteer rule. Well, if you look at it, you say, all right, let's say a mirror volunteer, the only time you can use that is in very rare circumstances, like as if it was altruistic, the payment was, or something like that. But in like the case that we cited in our brief, which is American Family versus United States, they pretty much said that a mere volunteer should only apply if the payment is altruistic. Other than that, mere volunteer should not be apply. The court in American Family also said that payments will be.
Let me ask you this question: is your policy ambiguous or unclear in any way as to whether Ravenell was covered for the injury in this case under your policy?
Is the policy clear as to whether or not Ravenell was covered under the policy, is what you're saying, is what you're asking?
Is it unclear and ambiguous in any way?
No.
No, so if it's not, then how can there be an arguable legal duty to pay?
Well,
Stick with the assurance, I think you're going to have some problems.
And I understand that, and I guess that's where I'm trying to go back and say, well, especially in the no-fault arena, what are we going to do? We're going to have lawyers going, or have insurance companies say, hey, rather than go through what we're going through here and the expense and the legal fees, we'll just go ahead and have coverage opinions every time this comes up, and with Michigan no-fault claims, and that's going to do nothing but delay it. To me, the better way to proceed is simply say, was it altruistic, and in this circumstance, was there any prejudice? There was no prejudice in this case. Auto Club had an opportunity to oppose my motion for summary disposition on the issue of damages. They also had an opportunity to appeal it. They didn't. Bottom line, there's no prejudice here. So what did they out?
I don't know if I even want to focus on prejudice, but I'll give you that. All right. If we look at prejudice, though, how are we to conclude that the insurer who was on the hook would have evaluated the claims in the same manner and paid them in the same way as you did? I mean, after all, your insurance company paid when there wasn't even any coverage. So maybe you paid on things that even wouldn't have been covered under their policy or under law. Well, and yet that has all passed, and you're looking for subrogation. And why should they have to go through the legal expense of paying lawyers to figure this all out when you were the one that made the mistake in this instance?
Well, I guess on the issue of prejudice, respectfully, the ship sailed. As I indicated, they could have, they got a complete copy of our pay log, and that was attached to our motion for summary disposition on the issue of damages. That pay log showed exactly what we paid. And if they had any objection to that, they could have claimed at our motion for summary disposition on the issue of damages, came back with their proof that what we did was not in sync with what they did. The insurers who pay no-fault claims typically pay, they all do it the same. And so, but again, if they wanted to do that, and they could have done it, that.
But you're the one that's arguing there is no prejudice.
Yes.
Prejudice really isn't the legal standard. For them, they're saying, hey, they volunteered. We don't have any obligation. So why should they have been under the obligation to look at the bill so closely and say, all right, you paid them wrong, we're prejudiced? That's the rule you want us to adopt. It's not the rule that was in place. So I'm finding it hard to conclude that they should have done it, as you've just articulated.
Well, that's not a part of this appeal and never has, I guess is what I'm trying to say, is that if they wanted to appeal the decision on the issue of damages, they could have done it in the Court of Appeals. They could have done it, it's been up and down in the Court of Appeals and in the Supreme Court. That is simply not an issue here as far as that goes. The prejudice, whether there was prejudice or not, has been conceded to be a non-issue by Auto Club. And the other part of this case, too, is that, the no-fault act is a different animal than any other insurance case. It's not like as if, for example, you have a policy that excludes intentional acts, and your insured goes ahead and executes someone with a gun without reason. It's very easy. There's no coverage. But if you look at the number of cases that have come down with the initial no-fault, I think I put in my brief, there's something like 8,000. And then you have 860 on priority disputes. So how do you end up getting it all right every time? Now, granted, this was not a priority dispute, but as far as this adjuster was concerned, she looked at it, made her decision, and as you pointed out, Justice Clement, she made a mistake. And so then why should...
Was her mistake reasonable?
Yes. They made a mistake just like we all make mistakes. Mistakes are unavoidable.
That doesn't mean every mistake that somebody makes is reasonable. All
No,
mistakes reasonable? Is that what you're saying?
I'm saying that under the circumstances of this case, the mistake was reasonable, and we pointed it out in our brief.
Okay, why?
Because of the complexity of the Michigan No-Fault Act.
Anytime somebody pays on mistake under the No-Fault Act, it's a reasonable mistake?
Depends on the circumstances. It depends on what exactly happened. This was quite a different situation. We had Omega Appraisals owned by Rona Ravenell, who was Mr. Ravenell's wife, the business is run out of their residence. It's easy to make leaps and say, well, okay, resident relative, and then the question is even further. Why did the claim get reported to MGM in the first place? Because the Ravenells reported it to MGM. Do you see what I mean? And so looking at everything, I think the mistake was reasonable.
They submitted the claim to NGM?
Pardon me?
They submitted a claim to NGM?
Yes, they did. They submitted the claim directly to NGM. NGM began paying it. There's another couple of issues here.
Do you think the defendant had an obligation at the outset of this, when they originally reached out to your client, to say, hey, we may be first in priority here?
I don't know.
Any due diligence?
There's not I don't know if there's maybe a legal obligation, but certainly a moral obligation. The question begs itself, why would you have called our insurance company except that you knew that you were first in the priority, and so therefore you called AAA, you called NGM to find out, well, hey, we're first in priority, we're the only ones in priority, so as far as we know, so why are you guys paying? This is a commercial policy, and there was no... He was even asked, did you ask him, this is commercial policy, any reason why you didn't say, hey, you guys shouldn't be paying? They essentially let the mistake go. And Auto Club cites in their brief the Stoddard case and the Citizens, or Salina Mutual versus Stoddard, and I'm sorry, I'm messing this up.
Let me see if I just follow
Sure.
what you just said. When AAA calls your client, they don't have the policy, do they? They don't have your client's policy, do they?
No, they don't.
They're supposed to ask a bunch of questions about what kind of policy it is and then tell your client whether or not there's coverage under your policy?
No, what I'm saying, from a moral standpoint, I don't think they necessarily had an obligation, but it's pretty clear, you ask anybody who does this, they would look at it. In fact, it wasn't me.
Somebody might say that they went beyond what their moral obligation was just by calling your client in the first place. Sort of check into the situation and,
why?
someone who thinks insurance companies are all, bad, they might suggest that they just sit back and wait for somebody to call them, right? But they were proactive, weren't they?
No, it was a tort claim is what it was. They had no reason to call us in the first place about the pit. They simply didn't. And pure and simple.
Say that again, they had no reason to call you except
Well,
for
with
what?
no reason to call in Jim in the first place. If they saw on the ISO.
Well, they were
that-
concerned that they might be liable under to pay benefits, right? And they wanted to see what was going on with this particular auto accident, right?
Right, and then, so then the question is, well, how come you're in that, how come you are paying the benefits, NGM? They didn't ask that.
Well, they're supposed to cross-examine your client when your client says we're gonna pay?
You just indicated that the question comes down to then, maybe Auto Club was looking at it and saying, well, maybe Auto Club, we are supposed to pay the benefits. So if that's
They
the
wouldn't
case.
know that, they wouldn't know that without knowing what type of policy it was, that it was commercial versus personal.
They would. It's commercial lines policies very rarely have have the named individual in it. And in fact, Selena Mutual, in the two cases that he cited in there, the cases are such that the name of the insured is in the in the name of the business. This
Okay,
case,
help me out for a second. So AAA is supposed to know that it's commercial and not personal, but the staff for your client didn't know the difference between the two policies and what was it, who was insured?
yeah, I'm just going based on Justice Viviano's question. I'm saying that it was more of a moral position. The case is Stoddard versus Citizens. The named insured is Stoddard's Lawn Shapers, Tim Stoddard, DBA. In other words, the name is in the company name. In the other case, they were looking at whether or not Robert Roode was entitled to benefits, no-fault benefits, as a matter of fact, under the policy that Selena Mutual had with Roode's record and mobile home service at the time of the accident. If he was considered to be an employee, he would be entitled to benefits under MCLA 500-31143. My point is both of those policies have the name of the person inside the name of the company. Omega Appraisals was Omega Appraisals LLC.
But that's not something AAA was in a position to know if they didn't have the policy.
Oh, yeah, they would know, because they would know this. They would know that it was Omega Appraisals LLC. And
Then
Omega,
again, they know what?
the name of the insured for NGM was Omega Appraisals LLC. It doesn't say Omega Rona Ravenell, DBA Omega Appraisals, for example. It didn't say that. So the point being is that if they knew it was an LLC, the chances are slim that that in fact probably non-existent, to my knowledge, doing this for 42 years and be involved in claims for 10 years, that an individual is actually named in a commercial lines policy. So. And I guess finally, I would like to emphasize, one other thing about the No Fault Act, very quickly here. There are a lot, AAA takes the position that this is simple when you get to the No Fault Act, and you said, well, couldn't they have just looked at the policy? Well, a lot of law firms have published manuals on it, on the Michigan No Fault Act. And some of those defense firms go not only in Michigan and do seminars on the Michigan No Fault Act, but go to other states as well and do seminars on the No Fault Act. I'm not aware of anybody that does seminars and just insurance coverage in general. And as I said before, with 8,000 cases deciding this, very hard to do it. And finally, I guess the end question for the court was that, was whether or not the equity, should be in favor of the subrogate. I'd like to emphasize that since this is equity, the equity should always be in favor of the subrogate, irrespective of why the payments were made, just so long as there's no prejudice to subrogate and seeking payment, that they're seeking payment from. I mean, if they're not prejudiced, what's the harm here? I just don't see it, because I can't identify prejudice. Thank you. Oh, if you have any questions. Thank you.
Taylor, you're out of time, but I think we have to allow you a brief rebuttal at least to tell us whether or not your client is immoral.
Thank you. I appreciate that.
You have 1 minute.
Really, just one,
Will
I'll make
No,
one
I'm
point
giving
on
him
that.
1 minute.
Our AAA adjuster only knew that a claim had been submitted to NGM. That's all they knew. They don't have the policy. They may know it's a commercial policy. I don't know if you can get that off an ISO or not, but that's beside the point. You can have personal benefits, you can have a personal named insured or an LLC named insured or an additional named insured. If it's DBA.
Why did your client call?
Pardon me?
Why did your client call NGM?
Because, as you pointed out, it was because they have a potential PIP liability lower in priority. We're in the bottom of the priority. The only one lower would be assigned claims. But he was looking into Auto Club's own potential exposure for a PIP claim and called them, not knowing what their policy would show, whether these people are named insureds or if it's a DBA or whatever it was. And we're assured we're covering the PIP, we're paying the PIP. I think it's prejudicial to then be surprised a year and a half later with a lawsuit for $300,000. But so that's one point I wanted to respond to. The other is on the question of fact, remand or whatever. I think it's an equitable doctrine. I think it's the judge's call as a matter of applying the tenets of equitable subrogation and the mere volunteer rule to make the call. I don't think it's a trier of fact type situation.
Okay, thank you very much.
Thank you very much for your
both. The case will
time.
be submitted.